Hey, welcome to the podcast. Today's topic is going to revolve around the Second Amendment. I'm going to read an article here from the Washington Post. A federal law barring people under felony indictment from purchasing guns is unconstitutional. A federal judge in Texas ruled Monday in an early test of the watershed decision by the Supreme Court expanding firearm access. U.S. District Judge David Counts found that the law prohibiting clashes with the High Court's June decision in New York State Rifle and Pistol Association versus Bruin, in which a 6-3 conservative majority ruled that law abiding Americans have the right to carry a gun outside the home for self defense. I always thought we did have that right. Apparently, places like New York, California, not so much. In the 25-page opinion by Counts, a Donald Trump appointee invoked the language of originalism, the conservative legal theory that the judges should interpret the Constitution based on how it was understood when it was adopted. That would be around 1791. Maybe from 1791 to 1805 would set historical precedents. The judge said he found little historical evidence that the law barring those under felony indictment from obtaining a firearm aligns with the nation's historical tradition. The Second Amendment is not a second class right. Counts wrote, after Bruin, the government must prove the laws regulating conduct covered by the Second Amendment in plain text aligned with this national historical tradition. The government does not meet that burden. Furthermore, he said the law is unconstitutional. The Justice Department said it intended to appeal the case to the U.S. Court of Appeals for the Fifth Circuit. I say good. That's where we want this. Because as long as the Fifth Circuit Court upholds and abides by the Supreme Court decision on how these things are supposed to be judged, by the single tier approach, not the two tier that they've been using for years to enact all these crazy gun laws. The two-step approach takes into consideration the feelings of the states and the government, saying that it's for the interest of public safety that they can infringe on our rights. In all the prior court cases, the judges have ruled, yes, you're right, this does infringe on your constitutional right. But we need to take a two-step approach to this because we have to balance it out to the public safety and concerns. Well, anytime you hear the words common sense gun laws, that just means, yeah, we want to take the Constitution, rework it like we're using a handful of Play-Doh and bend it to what we want because, it's not a real constitutional right. Well, that's not going to be the case anymore. The U.S. Supreme Court Bruin ruling just unraveled just about every gun law on the books. And by the way, just in case you don't know, the United States has about 30,000 gun laws on the books. I'm not making that up. Look it up. About 30,000 gun laws to date. I don't know how you can have 30,000 gun laws without repeating yourself many times. But apparently, when they create a new law, they don't check to see if that law already exists. They just do it to appease the voters so they can look like they're doing something. I digress. This case arose from the indictment of Jose Gomez, and I can't pronounce his last name, so I'm just going to call him Mr. Gomez for the sake of this podcast. He's of West Texas who bought a 22 caliber semi-automatic handgun in 2021 while facing state charges for burglary and jumping bail. According to the ruling, Mr. Gomez denied at the time of the sale and background check that he was under indictment. After Waiting a required week, he picked up the weapon from the retailer in Alpine, Texas. Now, see, in that state, in Texas, if your background check doesn't come back right away, you have to wait at least a week. If it still isn't back, the retailer can turn around and sell it to you. Well, soon after the National Instant Background Check System alerted authorities that the purchase was not legal, federal prosecutors charged Mr. Gomez in March with making a false statement during a firearm purchase and illegally receipt of a firearm by a person under indictment. Well, as you can imagine, after a jury correct, excuse me, convicted him on both counts, Mr. Gomez asked the court to reconsider his case in light of the Supreme Court ruling in Bruin. The ignorant government attorneys contended that the prosecutors were permitted to impose a wide range of restrictions on an indicted defendant. Keep in mind, indicted, not proven guilty. They don't even know the law about you're innocent until proven guilty. They're just accusing you. So you lose your rights? I don't think so. These idiots should be disbarred. They should lose their license to practice law. They don't know the law. In- Along with restrictions on indicted defendants, it's including detention and pretrial release conditions. But Counts, the judge, said the Supreme Court ruling had changed the legal landscape on firearm restrictions. He found that pro- prohibition Mr. Gomez from receiving the gun while under indictment amounted to a form of prior resistance that violated the Second Amendment rights. There is no illusion about this case in real world consequences, certainly valid public policy and safety concerns, the judge wrote. Yet Bruin framed those concerns solely as a historical analyst. This court follows that framework, and should all courts that hear any Second Amendment case. A public defender representing Mr. Gomez did not immediately respond to a request for a comment on Tuesday. The ruling comes a few weeks after another significant court decision on firearms access, in which a different federal judge in Texas struck down a state law barring adults under 21 from carrying handguns. The U.S. District Judge Marty Pitton found that last month that a constitution did not put an age restriction on the right to bear arms, meaning adults 18 to 20 should not be prevented from carrying handguns outside the home. Now, we all know Texas is very, very, very pro gun, but they got some rogue senators and congressmen in that state, and they pushed through a bill saying that in the state of Texas, 18 to 20-year-olds should be prevented from carrying handguns outside the home. Well, 18 to 20-year-olds are adults. So you cannot infringe on their rights. They do have these constitutional rights. Now, I don't know what these proponents of the Second Amendment, I don't know where they get their ideas from. I really don't. How much clearer could it have been that our forefathers wrote in there, in plain English, a well regulated militia being necessary to secure a free state, the right of the people to keep and bear arms shall not be infringed. Back when our fathers wrote this Constitution, they just got out of a war from a tyrannical government. Britain, they ruled the United States. We didn't even have a military at that time. That's where the militia comes in. Common everyday citizens brought whatever firearms they owned and as much ammunition as they had, and they formed the militia to overthrow the tyrannical government that was imposing sanctions and um, just plain out disrespecting the way of life. So they wrote in there the right to keep, meaning you can't restrict the purchase of, which I'll get into that in a minute. And then bear arms, meaning to carry. This shall not be infringed. Now, getting back to the minute about the right of the people to keep arms. There was, and I can't remember the details about this, but you're just going to have to take my word for it or try to look it up. There was a Department of Justice attorney that tried to argue, I think it was in Illinois, that tried to argue that they're not restricting people's ability to own guns just to purchase them. The judge almost fell off his seat laughing, saying, "Are you crazy? How is a person supposed to keep a firearm if they can't acquire a firearm?" That case lasted all but 2 minutes before he threw it out on his face. So that's about all I got for you at this time. This is a very short podcast. It's the first one I'm doing. Maybe down the road, I will, if I get an audience on this thing, maybe I'll take some questions, maybe some calling people, and we can have some really good discussions. Not all of my podcast is going to be revolved around the Second Amendment. That just simply is the hot topic right now, hot button topic. It's been for quite a while, and I'm just now jumping into the pond, getting my feet wet with these podcasts. So, yeah, you'll be hearing a lot more about it in the coming days. Thank you very much for listening. If you like what you heard, if you like my channel, Robert McCune, give me a like, hit the subscription button, tap that little bell so you get notifications. You know what to do. You guys aren't as new as I am. So have a good day, enjoy yourself, and please, please keep coming back and listening to my station.